name is Pranav and I belong to Faculty of Law and Governance. And in this session, we are going to read about Sociological School of Jurisprudence. Sociological School of Jurisprudence and Social Legal Studies and Sociology of Law. You might have heard all of these places many times in your legal studies. So before starting that, let me break what we have read so far. So, in orthodox jurisprudence, that is a traditional jurisprudence, you have read normative and theoretical part of law, right? In sociological jurisprudence, we read about normative and theoretical aspects of law with social emphasis. In socio-legal studies, we study pragmatic school, investigation of law in action, that is realism, and sociology of law, we read empirical theoretical study of law in social context. So the field of sociological jurisprudence, social-legal studies, and the sociology of law are distinct, though related, approaches to the investigation of the relationship between law and other social phenomena. So the main link between social legal studies, sociology of law, and sociological jurisprudence is to be found in the belief of scholars working within these school of thought, in the role that a study of working of the various elements of society as a whole or specific combinations of them under certain circumstances has to play in the understanding of the more specific operations of the law as distinct social phenomena. And the particular differences between these school of thought are to be found in an analysis of the main social issue which they seek to investigate, and the approaches which they take in relating studies on the law on these issues. So let's talk about sociological jurisprudence. So sociological jurisprudence is an intrinsically theoretical approach to the study of law, and it is specifically seeks to understand law as a particular social phenomenon. In terms of how it comes into existence, how it operates, and how it affects that it has on those how and the effects that it has on those to whom it applies. To this context, this school of law is very similar in its approach to other analytical schools of thought in jurisprudence, such as positivism. Its subject matter is laws proper in terms of Austin, right? He separated laws in two parts, properly so called and improperly so called. However, what distinguishes it from other schools of jurisprudence is its methodology. So at this juncture, I want to make this departure into the difference between methodology and methods. So methods can be anything, but the methodology is the reasoning or the logic of choosing any method. So if I have to dug a ground, there can be many methods, and I can choose any method. But why I'm choosing a certain method is a methodology. So I want to know law. I can know law by the help of natural law school. I can know law by the help of realism. I can know law by the help of analytical positivism. I can know law by reading literature and its impact. But why do I choose any one of them? It is methodology. So basically, looking into the logic of anything, it's methodology. The sociological jurisprudence seeks to examine closely the workings of society in general, in order to find therein the factors which determine the nature of law. Now, in this regard, it has historically relied on the findings of the social sciences such as sociology, as well as other disciplines, which includes obviously historical, political, and economic studies. And all of these disciplines explain the nature of law. So you see, as per Austin, law is nothing but command of sovereign. As per Kelsen, law is pure. But sociological jurisprudence makes law impure in the context of Hans Kelsen, right? Because he is here in the sociological jurist injecting historical beliefs, political beliefs, economic beliefs, and all sort of beliefs in the study and, and in the understanding of the nature of law. And let with this, let's begin the history of sociological school. Now, the history of sociological school is very long. What happens is there that it starts from way beyond Aristotle and what. So they all try to study what is the nature of society. But if at all we have to start, we should start it from David Hume. So David Hume, who in his treatise on human nature argued that law owed its origin not to some quirk of human nature, but to social convention, and who described law as a developing social institution. So law is develops social institution. Your marriage law is developing marriage, right? Marriage is already there, but what it is doing is projecting marriage into a legal manner. So it's creating an institution. Montesquieu, in his Spirit of Laws, put forward the view that law originated in customs, local manners, and the physical movement. So here you see Montesquieu can be considered in historical school also, right? He asserted that good laws were those which were in accordance with the spirit of society. Through the years, writers of the nature of society such as Augustine, Marx, Weber, Durkheim have contributed to sociological jurisprudence, putting forward views on how various social phenomena relates with each other and influence the nature of law. So the close link between theoretical study of the law on one hand and independent study of society on the other has meant that sociological jurisprudence has been closely influenced by developments in the other social sciences, and its views on the nature of law have been progressively transformed. So for this reason, it is difficult to point any one proposition as being the central approach of this school of thought. However, there are certain assumptions which can be identified as characterizing the thinking of almost all sociological jurists, and some of I will present some of them to you. So, generally, there is a belief amongst sociological jurists that law is only one of a number of methods of social control. Unlike Oliver Wendell Holmes and Roscoe Pound, who believed that law is social control, many other sociological jurists believe that law is nothing but one of the number of methods of social control. To this extent, it is not unique its function and its place in society. And there is this general rejection of the notion that law is somehow is a closed system of concepts. So when I say closed system of concepts, you have to understand this. So in analytical school of law, that is Austin's jurisprudence, you will see what does he say? Province of jurisprudence determined. So there is a determination of province. Now jurisprudence is this much only, right? In Austin's jurisprudence. Law is what? Command of sovereign, backed up by a sanction over. What is pure theory of law? It's a closed system. Beyond grand norm, there is no law. Beyond effectiveness, there is no law. What is law? Law is pure. So, in sociological jurisprudence, there is a strong rejection of the notion that law is a closed system of concepts, standards, structures, and that it can stand on its own in its operation. Because there are certain problems which only law cannot resolve. It must therefore be seen as being open to modification through the influence of certain social factors. To this extent, sociological jurists reject what has been called jurisprudence of concepts. As this we will see in Herring's jurisprudence. Herring propounded the rejection of jurisprudence of concepts. Now, sociological jurists tend to place more emphasis on the actual operation of law. That is law in action. Law is action. Law is not in theory. Arguing that real nature of law manifests itself in action rather than in textbook and in other elementary sources. Now, in discovering the building blocks of this law, building blocks of this school, sociological jurists disagree with the approach of natural law school of thought, which presupposes and proposes that there are certain sets of principles which describes absolute value and which then become or should be the basis of all law. Instead, they take a relativistic approach, right? They compare, which regards law as a being a product of socially constructed reality, right? So, to give you an example, Sabrimala, right? Before that, before Sabrimala judgment, law was something else. After Sabrimala, law is something else. So, law is product of socially constructed reality. The basis of the law is to be found in the ways in which people in society regard their situation and their place in it, and how society in general reacts to the problems confronting it. Triple talaq. Many people from the Muslim community has problems with the issue of triple talaq, and many of them haven't. So this was a social reality, and whatever happened, conflict, a law came out of it, a structure came out of it. This is what a socially constructed reality is, and this is how a society reacts to problems, and this is how law evolves. So there is this general interest in utilizing the findings of the sociological sciences in understanding the nature of law, and thus to make a law more effective tool for social justice. Now, views differ obviously as to what constitutes social justice and how best this may be achieved. We will look in coming sessions what are various views regarding what constitutes social justice, what constitutes social law, sociological school of thought. We will learn about hearing. We will try to learn about uh, pound. To give you an idea, hearing focused on purposes part of law. That law has a specific purpose, a practical purpose. Pound, Roscoe Pound, provided the meaning of law as conflict of interests, individuals' interest, society's interest, public interest. All of them are in continuous conflict with each other. And law is nothing but balancing of interests. Durkheim provided rationale for the society that there is this static society, that is mechanical society, and then there is organic society, which is very dynamic society. Mechanical society is small, dynamic society is larger as compared to mechanical society. When development happened, mechanical society broke up and it created dynamic society, and in dynamicity there is always conflict. Now you see, in Durkheim there is also a conflict interest. When all of this has happened, then evolved something, some reaction toward all of these methods. And afterwards we will see what is those reactionary views on law, wherein we will see about Karl Marx, critical legal studies, and then we'll move on feminist jurisprudence. This is all part and parcel of sociological school of jurisprudence. But since the major chunk of these schools are predominated by some other elements, they have been bifurcated in other schools of thought. Till then, thank you.